Hello, viewers. Great to be here again, this time with Thanuki Goonesinghe, a legal professional with a lot of interest in technology and very especially artificial intelligence and how it intersects with the legal stuff. Right? So today we are here to discuss about what is AI in very brief and how it intersects with intellectual property. But just to let you know that we are going to do a 10-part or 10 episode series, and we would be covering various topics around intellectual property and how it intersects with AI. Tanuki, welcome back again to my show.
Good to be back, Sujit.
It's always great to have you in my conversations. So, as I said, today we're going to talk about introduction to AI and intellectual property. I'd like you to tell our viewers what are the primary intersections between artificial intelligence and the intellectual property law. Tanuki?
Okay. So, when we talk about intellectual property, just a quick introduction for those who don't know what intellectual property is. It's anything that encompasses creations of the mind. So this can be inventions, literally, and artistic works, it can be designs, symbols that you use in trade and commerce. And some of the key terms that are used when it comes to protection of intellectual property, which you may have heard of, are patents, copyright, trademarks, which are the most commonly used three. Then you have others like industrial designs, etc. So an IP system essentially aims to maintain a balance between rights of innovators and the broader public interest. So keeping that in mind, the question was, what are the primary intersections between artificial intelligence and intellectual property? So the intersections actually come up when we talk about infringement. So whenever we discuss the ways in which your intellectual property rights are being violated, in that situation only we will start seeing where these intersections are. Like, for example, if we talk about the output of an AI model, if that output bears a striking resemblance to an existing work or product or a certain invention development process, then we see that there's some intersection there. Again, you see intersections when it comes to using licensed work for training purposes. So this is the big conversation of data scraping, downloading and processing materials, training data issues are another point of intersection. Then we also have producing AI generated output closely mirroring the licensed work. Then again, we have an intersection when we talk about infringing derivative works themselves. So those that have been derived from something else. In such a situation, if there's an infringement there, that too is a point of intersection. And lastly, I would say that if you are providing some tool to assist people to create an infringing work, there also an intersection would arise. So I think those are some of the observations that I have made in terms of the primary intersections between AI and intellectual property law.
So, would you also be able to say, in terms of who would be the owner?
Who would be the owner of the particular work? I would think that would at the
Yes.
moment, yes, that would at the moment be would at the moment depend on the specific case. But right now, as the law stands, there is the consensus globally is that the owner would be the developer or the
Okay.
person who is involved in creating whatever it is, or it is the it would never be the AI system.
Okay.
It would
So
it
in
would
other words,
always
we are
require.
talking the ownership would always be identified with a human and not with
Yes,
a
at the moment,
system
at
person.
the
So that's where the intersection also will be challenged, because you're using a tool to take derivatives or infer or make something out of something which already exists. So are there any other examples you would want to give in terms of how AI technologies that have raised significant intellectual property concerns?
Yes. Up until yesterday, I mean, this is like an ongoing thing. We have a lot of
Absolutely.
cases popping up almost every single day. So I think I just read yesterday or day before, two authors, Rebecca Mackay and Jason Reynolds, had filed a copyright lawsuit against Mosaic ML and Databricks. This was for because they had made these copies of the infringed works in violation of the plaintiff's exclusive rights under the Copyright Act. So there was no permission sought before using them. Right? So that is one. Then similarly, there was authors Andre Dubus and Susan Orlean, another AI copyright lawsuit against NVIDIA, where the training dataset uh, has included books written by the plaintiffs, that is Dubus and Orlean, um, without any credit, without consent, and therefore without compensation as well. So that was another case. And similarly, we've seen visual artists, Zhang, Anderson, Larson, Fink. They have filed a lawsuit, a copyright lawsuit against Google. This is because the company used their work without permission to train its AI-based image generator. Then we've been hearing a lot about the New York Times lawsuit filed at the end of last year about basically using content encoded within the models and live times content uh, to produce outputs without any compensation for the New York Times. And recently, a whole other bunch of, I think, about 8 other news sites have filed another lawsuit against OpenAI for the same. Then the Authors Guild of America in September of last year. It was a class action lawsuit against Microsoft and OpenAI and included thousands of authors, including George R.R. Martin, John Grisham, to name two people that people will be very well acquainted with, for again reproducing and appropriating words of words and copyrighted work of many of these authors to train their AI models. So a lot of these cases surround this aspect of copyright. Here and there, I have heard a bit of conversation on patents, but you don't have so much on like trademarks and all of that, the way the copyright conversation is going on at the moment. And just to highlight, OpenAI got a partial win in California, where a federal judge, has dismissed parts of a copyright lawsuit that was brought up by some authors, Sarah Silverman and Michael Chabon and a few others, against OpenAI, because that particular judge had joined a few other federal judges who have so far rejected allegations that or dismiss claims that the outcomes produced by generative AI systems infringe on the rights of copyright holders. Because there is a group that believes that this can be considered fair use, and that it is permitted. So you have that school of thought as well. So I think this is a judge that sides with that spectrum of the conversation. But a majority, I think, view this as not fair use. This just using it without any consent to train AI systems and to generate outputs that are very, very similar to the input data.
So, Thanuki, what I'm hearing from you is, while the adoption is going to increase, there's also a cause for concern that people may say that it is fair use or unfair use. So, I guess as we evolve into the future, adopting this technology, and with various other legal cases which are coming into our attention, would probably define the right balance. Yeah, at the end of the day, the technology may or may not know what is right and what is not wrong. So that's where the human supervision comes into play, where they have to determine fair use and rightful use. So, Taniki, thank you so much for taking time to talk about the introduction to AI and intellectual property. So, I'm going to wait for the next session where we're going to be talking about legal framework and AI innovation. Thank you so much.
Thank you, Sujit.